Hello, good night. This is U.S. immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Put your questions in the comments now so I can answer it. Tonight, I'm only focusing on immigration questions. Now, if you can ask me anything that's immigration related, I'll answer. And I know there's a lot going on, so don't waste this opportunity to ask an immigration attorney for information regarding what's going on in immigration. Thanks so much for the love. I appreciate it. I am on and taking questions. Yeah. All right. So ask me anything immigration related. I'm going to be on here for a little bit. Hi there. Hi there, Damien. It's nice to see you. And good night. Hi there, live on CDP. I know it's kind of late. Okay. I filed my VAWA with my attorney 5 months ago, no receipt notice. Yes, that is a thing right now. Receipt notices for VAWA, we are noticing it's taking anywhere from, on average, 4 months. We are even seeing some receipt notices go as long as 6 months. So, yes, that is happening. And of course, as you can see, they're changing a lot on the back end. And that is probably contributing to the longer wait times. Since the administration has taken over, we have seen those longer times just for the receipt notices. I know it's frustrating, especially for the humanitarian the humanitarian applications like T visa and VAWA. But what I often say is make sure you're submitting, if you are submitting this on your own behalf, make sure you send it by courier so that you can get proof of delivery and see that the officer did collect it. So if you have to trace it back or try to track it or show that you did indeed file it, that you have something to show for it. And it can be reassuring. My wife filed for annulment and court denied it and granted me absolute divorce, and I'm on the conditional green card. That's great. And that's a good step because annulment is bad news, right? Annulment means that the marriage never happened. And if that occurs, you would not be able to get a waiver going from the 2-year green card to the 10-year green card. You wouldn't be able to apply for a waiver. Furthermore, it would damage your application to go from a 2-year to a 10-year because usually annulment is granted when there's evidence of fraud in a marriage. So usually the person who is filing for the annulment makes the argument that they were defrauded. And so by the court denying that, the court has denied that argument and is rather saying this is a breakup, right, rather than fraud. So this is where it's very important to make sure you understand the consequences of divorce, annulment, separations when it comes to your immigration case. Now you can move forward to go from the 2-year green card to the 10-year green card based on at least the divorce waiver. Great question. Thank you for raising that because other people are getting this information. She made them separate me from the military. Now, it sounds like there's more going on, that there may have been mistreatment or abuse. That's the second waiver. You can apply for multiple waivers. And what happens is if one waiver doesn't get approved when you're going from the 2-year to the 10-year, you can have another waiver, right? Another waiver based on mistreatment or extreme hardship. Had a withholding in the past, got a I-130 approved, but green card denied. Is this a bad case? So it's a complicated case. Withholding, when you have a withholding, it does not necessarily fix the inadmissibilities. And that may be the issue here, is that an inadmissibility was not fixed during the adjustment of status phase. So there may be ways to try to bring it before the court, but we'd have to determine what the facts are. Why I'm assuming that it was based on something in your past, like the immigration. Usually, if somebody gets withholding of removal, it means that you didn't qualify for asylum, so you got withholding. But withholding is it's a very strange place to be. And I think that's why they're targeting a lot of people who are on withholding to detain them, because withholding often it still requires check-ins. Withholding also means that if conditions change in your country, they can then turn around and move to deport still, right? Can bring it back to the court, show that there's changed circumstances that now make your country safe enough for you, and then they can make a move to deport. So it's like you have like a temporary, they don't know when they'll take it away, but withholding isn't necessarily a permanent type of status. So when the judge granted you withholding, they're saying, we see that it's not feasible to send you to your country because you will likely be harmed in your country. So we're going to give you permission to stay here until something changes where you can go back to your country. So it's not an official status, and that may be the problem here. Can someone do the work without EAD if T visa application is filed and pending? Please let me know. Now, what they do not use working without a permit against you in the T visa process, right? So it's not saying that it is not permitted. It's saying, but they don't, just like they don't use the use of public benefits against you, because many of our clients do get assistance because they're in a tough spot. So we help them to contact social workers and organizations that can look at different benefits that they can get as victims of trafficking. And so it's the same thing, right? When the officer reviews the application, they see, okay, they got food assistance, they got housing assistance, they got the assistance varies, they got therapy. These types of assistance not held against them, and same for working without a permit, right? Because they understand, as you have been through a very hard time, the policy behind it is, you've been through a very hard time, you have to do something, or they're not going to blame you for trying to survive. So I wouldn't be, of course, nothing on here is legal advice. I wouldn't be able to tell you, go ahead and work, but it's not used against you. Can someone, let's see. Does this law affect persons that are already here? So I'm thinking you're talking about the pause on immigrant visas for citizens of 75 countries in the Caribbean, in Africa, in the Middle East, South America. And the answer is no. So if you're in the United States on status already, on green card, or you're applying for adjustment of status, that it should not affect you. This pause is for those who are outside of the United States. Can you live in another state from your husband and remove conditions? Now, when you're removing conditions, going from the 2-year to the 10-year card, I am going to tell you this, that's going to raise a major red flag. You have to make sure you tackle that in an appropriate way by really amping up the evidence to show the circumstances around why you're living in a different state. Also amping up more evidence. Did you have children since you got the green card? Did you have children together? Have you filed taxes consecutively for the 2 years? Have you moved addresses together, signed more leases together, bought property together? Is it that you are in different states for a necessary reason, like your career, or you're working, or you're going to school? This, you have to make sure that you are on top of the evidence, because it's going to raise questions for sure. I have good proof. Is it hard to win asylum? We have gotten approved under the administration for asylum. Is it hard? I don't, and this is where I say it's not a matter of hard, it's a matter of, do you qualify, and have you presented the sufficient evidence to be approved? So that's, you have to look at the elements of asylum, and I think that's what a lot of people miss. So this is why a lot of people do end up losing their asylum, or even filing asylum cases that will never win. A lot of people think that asylum is just for people who are afraid to go back to their country, right? And so, for example, when I'm talking to individuals and they say, I'm looking to see, do they qualify for asylum? One of the things that I will ask is, do you fear going back to your country? And almost every time it's a yes. And then I ask, why? Is it that you've been threatened specifically in your country? And sometimes the answer is no, not really. I won't be able to find a job if I go back. Unemployment is really high, the economy is really bad, or there's a lot of crime in my country right now that makes me afraid. And while those are valid reasons to be fearful to go back, it's not valid enough for asylum. With asylum, you have to fall into very specific categories. It's very specific. The threat, the fear that you have has to be very specific, and it has to be very specific to the specific categories. So the categories usually are religion. So you have a credible fear of persecution on the basis of your particular social group. That one is broad, and I ask questions to see what kind of organizations are you part of, groups are you a part of that's being targeted in your country. The others as political opinion, religion, nationality, ethnicity. So those are some of the categories that will allow you to get status. So one of the most recent approvals that we got, our client was a journalist in his country, and because he was reporting on corruption in the country, he started to become a target of the government in his country. And in addition to that, the government was also targeting his religious perspectives. And our client got the asylum 2 weeks after the interview. So Attorney Diana, you'll probably see Attorney Diana on the platform as well, attended the interview. We prepared him, we spoke to him, we made him understand how it's going to go, what to expect, and everything was fine. So it's not hard, but you need to know exactly. If you go into that interview and then you end up rambling on, or you're not very specific, or you have gaps in your timeline, which sometimes happens, especially after you've been through a tough time, that can endanger your case. So very specific here. So you need to know the legal basis. If you don't know the legal basis, get an attorney. Are you in Canada? Nope, I am a U.S. immigration attorney. So only in the US. I represent clients in all 50 states, though, and the globe. So wherever you are, no matter where you are, I can assist you. So if you're in Canada and you want to come to the United States, I can represent you then. But if you want to go to Canada to live, I cannot represent you then. Um, I filed VAWA in March 2025, but still I didn't receive a receipt notice yet. 10 months already. I'm worried. Should you refile? No, 10 months is a long time. The one thing, there are certain actions that you should be taking before refiling or assuming that it's gotten lost. One is you definitely have to track it down by calling. So that has happened where, I had a client who retained us afterwards. We needed to locate the client's previous filings from another case that she never received. So we tracked it down by first calling USCIS, talking to usually a second tier officer about this. And it can be frustrating because sometimes it takes days or weeks to get through to a second tier officer. I'll bet that that is going to get worse. But you need to take the step to first track it down at USCIS and confirm whether or not they have received it. If they 10 months is a long time, if you've done everything and you've assumed that it's lost, then at that point, refiling may be an option, especially if you want to make sure that, especially if there's a deadline, by the way. Had a withholding in the past, so I answered that. All right, so now I'm on Instagram answering questions. Hi there, Karen. I see you on Facebook. Can I pause my removal proceedings if my U visa is pending? No, not the way you think. So sometimes the judge will give you enough time. Now the U visa does take very long. So the U visa can take 10 years. If you have a bona fide, like you have a work permit, then you may be able to go to the court to either request that the court terminate the proceedings or continue the proceedings. What we are seeing is the judge will push out the case in order to allow more time. Sometimes they'll do status updates to see where the case is. So it what the strategy is going to depend on where are you, right? Have you just filed a receipt notice? Have you gotten the receipt notice? If you haven't gotten the receipt notice, then you know then it's really a hard argument to bring to the judge that they should terminate proceedings altogether. But the judge may then do a status check where they do schedule another master hearing, then to get an update and then determine how to move forward from there. Second prima facie so far, but no EAD. Yeah, and you're probably gonna get about 4, 5, or 6. Well, no, sorry. Before I was talking about approval. I wouldn't count prima facies when it comes to EAD, but I am noticing that work permits are taking anywhere from 6 to 12 months to get, and that really has been across the board for many years now. Can someone do the work EAD if so? I answered that already. They don't hold working without a permit against you with a T visa. Um, my mom filed VAWA under category C09, which is for the work permit, and it's been 15 months, no work permit yet till now, and I'm not from the 39 countries. Is that really normal? It's not surprising. If you check now, based on my firm's experience, my average timeline for work permits is 6 to 12 months. But if you look at USCIS case processing timelines, it can go longer. So it really depends on the case processing timeline, and the case processing timeline may be around 15 months as well. If my U visa is pending, can I pause removal proceedings? So I answered that. You are you're on late tonight, very dedicated to the mission. Thank you for that. Thank you for recognizing that. Yes, it's been very busy. And of course, there's a lot, and everybody is busy right now. And so that's why I was busy before, and it's now crazy. It's crazy busy. So we're working double time to just make sure that everything is straight for our clients, that when we get these cases that we put our best foot forward, and that does take time, but I'm here to answer questions because you need to have a resource as well. As a healthcare worker who's undocumented, can I get work permit leading to citizenship? So, unfortunately, being a healthcare worker alone is not enough, even though the work you do is so valuable. But I want to be able to talk to you. I want to talk to anybody who wants to be here and get protection and get their work permit and eventually get citizenship, because we work with multiple options. We ask questions that not a lot of other lawyers ask to get to the solution for you, but you will never know unless you get in touch with us and talk to us. You can go to the link in the profile right now and schedule your own appointment, and we do an initial evaluation first to determine whether you can qualify for an option. You could potentially qualify for an option. If we see that you can, then you can move forward to scheduling that appointment on your own, or you can go ahead and call us. Our phone lines go 24/7. If you're calling right now, then we'll call you in the morning, first thing in the morning, to get you scheduled for an appointment. Thanks so much for the gifts and the love on TikTok. I really appreciate it. And I'm coming very quickly on, I'm coming back to TikTok to answer more questions. So, okay. So now I am, let me see. Do you think they will lift the pause? Yes, I think eventually they will. When is going to be another question. And then I'm just gonna say this. I always approach cases by life with positivity. And I'm solution oriented. Whenever there's a problem, maybe freak out for a second or two, and then it's time to get to solutions, right? That's what has made my firm very successful, and that's why I'm so persistent in defending my clients and protecting their rights. Now, when we talk about that lifting a pause, do I think they will lift a pause? Yes. What kind of fresh hell will we be in when they lift the pause? That's another thing. I mean, it's really hellish right now with a pause, the uncertainty of it. But here's my solution with the pause. It's not over. You still apply, because that's the goal, right? People get so confused by the fact that there's a pause. Some people have the misconception that it is a ban, that they know they don't qualify to apply, and they miss their eligibility timelines, right? They miss their deadlines. They don't take the opportunity to apply when they should. So still apply. That's step one of the solution. Now, the other part is they're pausing this to be able to create new policies, probably vetting procedures, which will probably make the process more challenging. And so we have to see what that's going to look like. But keep this in mind, even though the policies may be different, and undoubtedly, as we have seen, they will create policies that make it hard, especially for the average person to just apply. What I would say here is there is still the statute, the actual law, right? Government has to tailor regulations and policies around the actual statute. And the actual statute still says the spouse of a US citizen can qualify for the green card, right? So if you're the spouse of a US citizen, you qualify, and you should make us worry about the how, right? We will work with you to deal with the how, because that's my job as a lawyer. I'm here to solve these kinds of problems. So let's look out for the pause. I think the pause will come. I don't know when though. I mean, not the pause. They will lift the pause. I know that's going to come at some point, but I don't know when. So first solution, still look at your options to move forward with your process. How long it may take to schedule citizenship appointment? Again, if you didn't pass the first test, about 2 months, 2 to 6 months. So just study, get to make sure you can pass that test. Do you do green card lottery applications? No, we don't do that at this time. If I apply VAWA, will it help me prevent deportation? It possibly could. There, in this time, what I would say is better to have a process that you qualify for than not at all. If you are and end up in a situation where you are detained or referred for removal, you never filed that VAWA that you qualified for, then it's like yelling into the once you're detained or you're in even in court well, if you're in court, you'll be able to bring out what's called VAWA cancellation of removal. But keep in mind that the court is a lot more stressful, right? And if you are detained with no pending process, maybe worse, you have a removal order. It's like yelling into the void, right? Wait, I know you can't deport me. I qualify for VAWA. Um, it gets a lot harder, right? To explain this to lawyers, to explain this to the officers. They're definitely not listening for sure. So it's best to have something on the books in order to ensure that you can possibly have a good fight to stay here and even not get to removal proceedings. We did have a client that ended up detained. So they were detained and they had a removal order. And it's because they have a pending process that we were able to get a stay on that removal, meaning that they can't deport them because they have that pending process. So it gives you the ability to fight, especially now that immigration, they are targeting people who have final orders of removal. That's a number one priority for them. So it's important that you safeguard yourself, give yourself a chance if you qualify. If you qualify for something, talk to us, and then let us help you. And that's another thing we do. We do look at risk. So as we are talking to you, we're advising you, we're also taking into consideration the changing landscape, changing policies to be able to help you to control the risk. So to understand how to approach the risk. I'm starting a job on OPT. I've told them my work authorization card is arriving. Do I need to tell them I'm OPT? I'm scared it may put them off. So I can't advise, this is very specific, and I can't advise you on, you should definitely be as upfront as possible. Now, if you have OPT, then you should be able to prove that you have the OPT, and they should also be doing a check on their end. What you should not be doing is signing any I-9 documents, putting false information, or, for example, putting false information of that you are a permanent resident or that you have any other type of visa. That will surely they are targeting individuals who do that as well. And they come down very hard on them. So it's important to be as upfront as possible and make sure you're telling the truth, that you're not signing documents saying otherwise. If they're assuming that you work, that you are working indefinitely, I would just want to know where they got that information. So get legal advice for sure. Because yeah, that's a hard position to be in. You don't want to get yourself into trouble. I have a friend that has been in removal proceedings from 2022, get 2 kids, and he's still here. Can his situation be fixed under this current regime? He's seeking asylum. The asylum may be the fix, right? But it might be in court that he's bringing his asylum case in court. So believe it or not, he has to win the asylum case in removal proceedings. What I want everybody to understand as well is being in removal proceedings is not an end all. If you have a solid asylum case, a cancellation of removal case, that a judge will hear, that means that that judge can give you, instead of ordering your removal, that judge can actually give you the status to stay in the US. So they really have to look at winning the asylum. And does your friend have other options that they should be looking at as well? For example, the T visa, just by getting the T visa, it can then turn around and we can terminate the proceedings because now the client has status, because a USCIS can make a decision on T visas even with a past removal order or if a client is in removal proceedings. How long BFD after biometrics for T? My case is pending since May 2026, so 6 to 8 months after the biometrics. What site can I go to check if I am in removals? So you can go to the EOIR. You'll have to Google it because I don't have the link on me directly, but it's the EOIR case status. Case status. And when you do that, you'll see the official site. Go there, type in your A number, and you will see the court will tell you the current status of the case. Is citizenship interviews being canceled? If you don't pass the interview, after how long they're going to make the appointment again? Some are being canceled, especially those from countries that are banned. They are pausing immigration processes for some of those countries, and because of that, they have canceled citizenship for some people. Is it true that overstayers can be forgiven by marrying an USC? Yes, yes. When you are now, if you the marriage has to be bona fide and real, but if you once you pass the process, it means that they will not hold it against you. So they won't hold it against you. If you filed an I-130 under the F2B category while you're in the country, can you travel back and forth? No, definitely not. As a matter of fact, and this is where I say, hopefully you're asking this because you haven't filed it, because you need to understand what the risks are. Believe it or not, filing an I-130 alone can put you at a lot more risk. And this is where I say no case is simple. Uh, it can put you at a lot more risk to file an I-130, but not be able to file an I-485. And you definitely would not be able to travel back and forth. Now, if you're, say you have a visa, temporary visa, you filed an I-130 and you're outside of the United States, right? You didn't overstay. You may be able to travel back and forth on a visa. Keep in mind that the officers may ask you questions about that, and you need to provide them sufficient proof that you will return to your country. But if you're here in the US, you overstayed, and then you file an I-130, you cannot be moving back and forth just based on a filing of an I-130. Thank you for that compliment. I appreciate it. It's been 2 years since I filed VAWA. It's taking about three, even 3.5 years. And if you look at the website, I believe we're approaching 4 years. But keep in mind that's the longest timeline. But 3.5 years is what I'm seeing right now. And now it's really the time is going longer and longer. All right. Okay, I'm on TikTok now. Can I still file for my husband I-130 and I-485? If you're a U.S. citizen or permanent resident, that may be a possibility. But filing an I-130 and I-485 based on this fact alone wouldn't be something I'd be able to answer until we talk to you in detail. So get on a consultation, you do the initial evaluation for us to understand your situation, whether we can help. If we can, then schedule a strategy session so we can talk about your case and then be able to advise you specifically. Wow, 7.7K likes. Thank you so much. That means that other people will see this information that will empower them in their immigration journey. So keep it up. Thank you so much. Can you travel overseas with green card extension letter through VAWA renewal and have no re-entries? I'm a little, so I'm thinking you have your green card. Is it your 2 year to the 10 year? I would say I'm conservative. I would take a conservative approach in traveling. If you want to travel, you have an extension, you need to understand your risk level. Everybody now has to understand their individual risk. If you're applying for the 2 year to the 10 year based on VAWA, which means mistreatment, the officers may have additional questions when you're coming in. And I have heard about them putting people like this in secondary inspection and then questioning them about their application. So that's dangerous. And that means that the officers are now gathering information, really reviewing some aspects of your application when you're coming back into the country. So if that's the case, why risk that possibility? So it's really determining your risk level and what it's worth to you. I have interview on February for marriage visa. Is there anything new to pause migrant visa? If you're in the United States, and you're going to your marriage-based interview, it shouldn't affect you. Even if you're a citizen of a country subject to the pause on the immigrant visa. If you're outside of the US and they're still scheduling interviews, they will not issue you the actual visa until they've lifted the pause. Can I still file for my husband I-130 and I-45? Let's talk about the pause, right? So if you're talking about the pause, like, is this, you can file it. If just by filing I-130 and I-45, it means your spouse is in the US, and there it doesn't apply to your spouse in the US, but still make sure you're getting legal advice and representation, because no case is simple right now. I have interview on February for marriage visa. Is there anything new to pause migrant visa? So I answered that. I'm a conditional green card holder, still married to a US citizen wife. Can we travel internationally? As I said before, it really depends on your individual risk. Were you recently arrested? Is there anything in your background you're concerned about? Certainly, traveling with a spouse who petitioned for you in the first place is a good sign. But are there any individual circumstances you're facing that could put you at a higher risk, like being arrested or convicted for any kind of offenses? That is where you need to also be looking. Okay, so he overstayed. And then I just rule, if overstaying alone is not going to disqualify, if you are a citizen and your spouse is, your spouse is, you're a US citizen and you're petitioning for your spouse. However, there are a number of questions we ask. Once again, this is not the time to simplify the case, and understanding fully the complexities and the risk and what needs to be done really has to be done in a consultation. It's been 45 months of filing VAWA. What is the processing time of VAWA these days? You can go to USCIS case processing times and you'll see the longest time for processing right now. So I have interview with the new ban. Can I still get renew visiting visa? If you're talking about the pause that citizens of 75 countries are subject to, it does not affect the visitor's visa. It's been 45 months, so I answered that. If I withdraw my 2-year green card petition on spouse, then he got the green card. So I don't, for me, I don't necessarily, this is not what I advise on. You can always talk to maybe another immigration attorney that represents the citizens, or you can talk to your own attorney that represented you on your 2-year green card, on your green card petition, the original one. That attorney would be able to assist you. But I don't usually advise on telling people how to make other people lose their status. I think that's like somebody else that does that, but not me. It's been, hello, can I prove that I need to, how can I prove that I need to wear a wig for biometrics pick? I don't know if that's a valid question, but you should be able to wear one. They don't necessarily require you to wear your real hair, so that shouldn't be a problem, as long as it's not obstructing your face. Can you travel overseas with green card extension through VAWA renewal? So I answered that. Talk to your attorney for sure. A person deported in 2004, 5 years, migrated in 1990, could residency be reinstated? That is complicated. If the person was deported, that means that they lost their status at that time. So they wouldn't be able to get it reinstated because they lost it in the deportation. So if that's what you're asking, they can reapply for a new one, but not necessarily get the original permanent residence reinstated. How long does it take to apply for a re-entry permit? So that one can take anywhere from 6 months to 12 months to get. Now, if you are applying for a re-entry, and that's why you need to start ASAP. If you know you're going to be outside of the country, you need to apply ASAP as soon as you know you're going to be out of the country for up to 2 years. How long does asylum decision take? It can take a few months. So we've gotten decisions in 2 months, but it could also take years. Is it safe to apply for a green card as a newlywed? Great question. The reason why this is a good question is because really and truly, whether your case is going to be approved is going to depend heavily on the evidence that you provide. And one of the main challenges of newlyweds is the fact that you're newlyweds, you don't really have much, you're starting life together. But it doesn't make you helpless, but it does mean you need to jump into action very quickly. So, as a married couple, you both want the best for each other, and you know that it's time to build that life together. Don't wait, right? Make sure you're building a life together. Don't waste any time. Get the bank account going. Make sure that you're using the bank account. Come up with plans together, have a estate plan in place. Put each other on your car insurance. Get a health insurance. Put each other on your health insurance. Make sure that you are gathering evidence of photos, but not just any photos. For one, I'll give you a little helpful tip here. Sending selfies together all the time is a red flag to immigration, even selfies of you both as a couple. You have to spend time together with friends, family, different holidays, different seasons, different times, different vacations. Document all of that. Do you have your travel ticket showing the courting period where you were back and forth visiting each other? Start putting those documents together, right? You're not helpless, you're married. So make sure you're starting to just be proactive and get your documents. And that doesn't have to take very long. It can take like about a month to, do these things, get these things together. Because really and truly, what you're doing is you're showing the officers the timeline of your relationship into your marriage, right? And how you have now been building a life together. That's what the officer wants to see. Can you travel? So I answered that. Wow, a lot of questions on TikTok. Let me see if I can get to. I believe I answered these. Okay, let me see. YouTube, Facebook. Wow, some more have come in. I'm gonna answer these, and then I'm gonna head out. And good morning to you all. Now it's morning, so you we basically spent 2 days together. Technically, we spent Tuesday and now Wednesday. How many days get work permit and travel document after prima facie? So usually 6 to 12 months after filing. I don't usually go by the prima facie. I have 10-year green card, which was approved after my marriage was over 2 years. I received a reminder notice from USCIS to file I-751. Is it proper to do that? It may be a mistake. Just make sure you call them and make it clear to them that you received the notice, and just establish that it is indeed a mistake on their end. What consequences are there when ICE agents attempting to enter an Ecuadorian consulate? So yes, it is a violation of international law, and I am seeing that. This is just an example that these ICE officers are not, they're not trained on the law. And that is why we're seeing so many first, second, fourth, and fifth amendment of violations of the Constitution, is because ICE officers really are getting the wrong idea about their role and their limits. So this is an example here. Now they attempted to enter, they didn't actually enter, but that is a serious violation of law. The consequences, you know, I am not versed too much on the international law and what those consequences are. Frankly, on international law, as you can see, has very little teeth to it. But it is a type of law that has to be respected, or else how are they going to be able to function diplomatically across different countries? So I'll bet that they will definitely tackle this behind the scenes with the ICE officers, but I'm not aware of what the consequences would be. If you get the email from USCIS, acceptance confirmed, and you have an alien number, next state, it's safe to travel. I'm not sure what acceptance that would be. I have filed I-130 as a green card holder, and it has been over 8 months. I heard nothing from USCIS. Is that normal time? I am from a country from ban list, and beneficiary is from suspension country. So they are pausing, and so you should still be getting a receipt notice, but they're probably taking a while on it. They're not prioritizing issuance of receipt notices, so you might see correspondences getting longer just because of the pause on all applications right now. What I would say is track to see whether it was delivered, and also call them to verify whether it has been issued, and maybe was there a mistake? Did it get lost in the mail? You have to follow up with USCIS on that. I just got biometrics done for VAWA. What is the next step? So the next step is going to be the work permit. If you haven't gotten the prima facie already, the work permit, which takes about 6 to 12 months from filing. Hey, good night, Kingston Wizard. Can I pause my removals to answer that? All right, and let me see Instagram before the phone goes out. Let's see, I'll take one more question. Where do you keep these pictures? On your phone or other devices? Good morning from Orlando. Hi there in Orlando. You on different devices, whatever devices you have, and then you just print them out when you're ready to present them to immigration. What is the acceptance rate, wait time of someone in the US applying for EB2 perm while on OPT? I'm from one of the 75 banned countries. Does the ban affect me in any way? So the ban doesn't, you're not banned, but now they're pausing applications from 39 countries in the US. So if you're here in the US, you qualify for the NIW, so EB2, file it, but it's going to be a little while delay because they've paused. How long does permanent resident need to wait while the petition is filed? So you have to wait for the priority date to become current. So we're seeing it, the movement about 8 months until it becomes current. So that does play a lot into when your relative will qualify, especially if they're in the U.S. They have to be maintaining their current status while waiting for the priority date to become current. If a petition owes child support and tax, can that petitioner file for their spouse? Yes, but I would just say those may be questions that they raise. It can be challenged in that the nothing in the policies say that the that that should result in an inadmissibility of a relative who they're filing for. Um, but yeah, you want to resolve any kind of issues like that, especially seeing that they may even use it against you for public charge reasons. If there's child support issues, tax issues of the petitioner that's involved. All right, everybody, thanks so much for your time tonight. I appreciate it. I appreciate being here with you and spending the time with you. As always, make sure you go to the link in the profile, go to the link in the description of the video on YouTube, click on the link, and you'll be able to do an evaluation. It's free, and then schedule your own appointment or give us a call. Our number is 24/7. We're a confidential phone line. Call us and we will call you as soon as we can on the next business day to schedule. Now, we are running the phone line 7 days a week, 24/7. So you can call at any time and we will then help you to schedule an appointment. All right. Have a good night, everybody. Bye bye. Or rather, good morning. Have a